Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are robinfrazierclark and lestertate, who are both past presidents of the State Bar of Georgia and currently serve on the Board of Directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am robinfrazierclark, and I'm here with my co-host, lestertate. Good morning, Lester.
Good morning. How are you?
I'm fine. How are you?
Doing great. Glad to be back for another episode here.
Same here, and I think before we begin, we ought to note that today is Election Day, and get out and vote if you haven't already. I've already voted by mail. You voted yet?
I have not, so I'm going to get to stand in line today, I'm thinking.
Well, I've already checked on Twitter, and hashtag Fulton County is trending because of the long lines in Fulton County.
Well, hopefully, as a country lawyer, I've got a little shorter line up here in Cartersville, Georgia. We'll see.
Let us know. Today, folks, we're going to be talking about appellate law practice and what that is and what that means. And to help us understand it, we're thrilled to have Georgia lawyer Mike Terry with us on the show today. Good morning, Mike.
Good morning, Robin. How are you doing?
Doing great. How are you?
So far, so good. We'll see how this goes.
Let me tell the listeners a little bit about you, Mike. Mike Terry represents plaintiffs and defendants in complex commercial and appellate matters, as well as class action. Over the past 15 years, his practice has focused heavily on appellate litigation, particularly in the areas of class actions, and punitive damages. He is a fellow of the American Academy of Appellate Lawyers, an organization founded to advance the highest standards and practices of appellate advocacy and to recognize outstanding appellate lawyers. Mike argued the landmark Georgia case, Atlanta Oculoplasty Surgery PC v. Nesselhut, in 2010 and achieved a 7-0 victory before the Georgia Supreme Court in a challenge to the constitutionality of the state's caps on pain and suffering damages in medical malpractice cases. In 2016, Mike argued and achieved a 7-0 reversal of the denial of class certification for a class of consumers alleging they had been charged usurious fees by their bank. In 2015, Mike was selected by the Council of State Court Judges of Georgia to represent that body in a Georgia Supreme Court challenge to actions taken by the Georgia Judicial Qualifications Commission. A strong supporter of the Atlanta legal community, he has served as president of the Atlanta Bar Association, where he set a focus on judicial funding and services for lawyers in transition. He is also a member of the Georgia State Bar Board of Governors, and he is a frequent lecturer and author on business litigation topics, including class actions, punitive damages, and appellate issues. He is often asked to moderate debates and panel discussions involving judges. And you can find out more about Mike at his law firm's website, bmelaw.com. That stands for Bondurant, Nixon, Elmore, bmelaw.com. Mike, welcome to the show.
Thank you.
Glad to have you.
Happy to be here on Election Day.
Have you voted yet, by the way?
I have. I voted by mail, and I also went to the My Voter page and made sure that my ballot was received. And everybody who voted by mail should do that.
We did that last night.
If it wasn't.
I just want to say that as much as I favor mail-in voting and being able to mail-in vote, as a lifelong procrastinator, I am glad to still have the opportunity to go vote on the last day.
True, I agree. Let's hope it goes smoothly today. We're in, Mike, in a pandemic right now, coronavirus pandemic, where our courts have been closed now for a while. They may be closed a little bit longer. We're not sure. Have you ever experienced anything like this? And how is your practice getting along? How are you going forward with your practice in this?
Well, my practice has been extraordinarily busy. I've now had 12 remote arguments, mostly by Zoom, 11 by Zoom. And the courts have adapted extraordinarily well. The practice is going well. And the one thing I will say is particularly our Supreme Court has done a great job of managing the pandemic from a systemic court standpoint and handling their own business extremely well. The Zoom arguments there, the professionalism of the staff and the way they bring you in advance and have you practice, et cetera, to make sure that the flow of information is not interrupted by technical issues has been really great. As far as seeing anything like this, the closest thing I would say would have been right after 9/11, where for a very short period of time compared to this, things were shut down. And even after that, there was a lot of hesitancy in putting crowds of people together as we tried to figure out what additional danger of further attacks there was.
So one of the other things that's going on, Mike, right now are the massive protests throughout the United States, even abroad in places like London and Paris and Stockholm, arising from the death of George Floyd, allegedly at the hands of a police officer, although we can all see the video. As a lawyer, I still believe allegedly is appropriate for those accused of a crime. But one of the issues that I've heard a lot of talk about is the issue of qualified immunity. And for our listeners who don't really know what qualified immunity is, it gives police officers, law enforcement officers, and some other public officials an actual immunity from being sued or being called to account for in front of a jury or peers. It is a judicial doctrine that came out of the appellate courts, not by any statute or other enactment by the legislatures. So I was wondering if you have any thoughts about that and where that might be going and how it might have bearing on folks who are the victims of police misconduct actually being able to get a little justice in the civil court.
Sure. Actually, I have pretty strong opinions about it and guesses as to where it's going. One of the concept of qualified immunity is about 38 or 40 years old. And as you said, a judicially created doctrine. And the idea is that police officers, because they're acting in emergency situations, but other government entities as well, even in non-emergency situations, should only be held to account for violation of constitutional laws if it is clearly established that what they are doing violates the law. That doesn't sound like a horrible idea until you see it in application. And particularly the way it developed over the years as simply a protection device for the government and for the police. So, for example, to be clearly established, you had to have a published case on all fours saying it's a violation of constitutional rights to do X. Now, this led to two serious problems. The first serious problem is people wanted it to be too precise. And in one of the famous cases, there was an older case saying, if you tie somebody to a hitching post and whip them, that's a violation of their constitutional rights. And then later, they tie somebody to a telephone pole and whip them. They said, well, there's no case saying you can't tie them to a telephone pole. Now, the idea that you're not on notice, even in the first instance that you can't tie up a suspect and whip them, it doesn't matter what you tie them to. You shouldn't need one case to tell you you can't do that. And you certainly shouldn't need one with the same, kind of pole. But the other more insidious part of this is that the courts then, and I'm not ascribing bad motive when I use insidious, but that was the result. The courts would look at this issue before they looked at whether it was a constitutional violation. In other words, is there an earlier case saying this is unconstitutional? It's directly on all fours. And if not, we're not going to decide whether the conduct was unconstitutional because there's immunity. Well, the problem with that is it never advances. If you never have a decision saying, if you hold a prisoner in the back of your cop car in 100-degree weather without water or air conditioning for 5 hours, that's a violation. Well, if that comes up and it's never come up before, and you say, well, there's immunity, so we're not going to decide if that's a violation. And then the next time it happens, there's still no case saying it's a violation. So the law never advances.
One of the problems that I see with the qualified immunity, we've now, for years, police officers who engaged in misconduct never got indicted. But even those that get indicted, the idea that a jury is going to convict them when the standard of proof is beyond a reasonable doubt, and they're all of these factors that sort of go into qualified immunity are presented there. It makes for a lot of disappointment, I think, for the victim's family sometime when there's an acquittal there. But do you think it's fair to say that right now with qualified immunity, there's literally no other avenue for justice on behalf of the family of a victim of police misconduct?
I would say that is not 100% accurate, but very close to it. I mean, sure, there are going to be times that juries are going to convict, and increasingly we have video evidence, which makes it hard. But we've seen in the last few years acquittals with video evidence that any layperson would say was dispositive. But I think we may be on the verge of either trimming back substantially or eliminating the qualified immunity defense. We've had both Clarence Thomas and Sonia Sotomayor saying this doesn't seem right. Now, when you have those extremes, those polar extremes, it reminds me of when we had a vote on the Patriot Act many years ago, right after 9/11, and there were two Congress people who opposed it and said it was unconstitutional, Bob Barr and Cynthia McKinney. And when those two combined to say this is unconstitutional, maybe people ought to listen. And I sort of feel the same way when Clarence Thomas and Sonia Sotomayor are both saying, well, what really is the basis for this doctrine other than us 30-something years ago?
Well, the Congress could get rid of it if they wanted to.
There's a bill pending. There is a bill pending in Congress, but
which I think was introduced by a former Republican congressman from Michigan, which is trying to attract.
Now, I think now libertarian, I guess.
I think he just it says he's an independent, but
he's going just an homage.
So one more question on this, Mike, and then I'm not going to hog the mic from Robin, but
both respects, yeah.
Exactly. If you're talking about, a lot of people say, the police officer ought not have to pay out of his pocket, but every other employer, if their employee takes a bad action, if the Coca-Cola truck driver runs over you, Coca-Cola is responsible for that. And so what do you think about the idea that the cities or counties or states or whoever is the employer and charged with training these folks, that they're the ones that really ought to bear the economic risk of that misconduct, and that as in some other areas where lawsuits are filed and you get increased safety, like for automobiles, for example, it becomes safer over the years because of suits about seat belts and airbags and things like that ultimately that exerts pressure on the law enforcement community and on the cities to have a better trained, more de-escalating law enforcement community to avoid these types of misconduct cases.
Well, a lot of it actually depends on what the governmental entity is. For example, a city can be sued under Section 1983 if the misconduct of the officer is the result of a policy or practice of the city that causes, in other words, we're not going to train, or we're going to adopt a policy that you beat the crap out of suspects. If your mayor instead of your president says, I want you to get rough with them when you arrest them, don't be too gentle. So if the city has a policy or practice that leads to the constitutional violation, they can be held liable for it. The problem is states, we've got sovereign immunity for our states that has a much stronger reach.
Well, I think we all agree there's work to be done. Something needs to change. It's in a bad situation right now. And these family members need justice. They're not getting it. They're not going to get it until something changes.
And I would urge, the lawyers listening to this to get involved, not only as, protesters or what are we now, allies or accomplices, but actually get involved as lawyers. And groups like the National Lawyer Guild are organizing legal observers for the protest. You provide services such as observing arrests, making sure that people know what jail the person being arrested is going to. Frankly, there's a great effect from having the police know their arrests are being observed by a lawyer. And so that's something that I've done, and it's a legal service where we can use our particular talents and expertise to protect the constitutional rights of those exercising their constitutional rights.
That's a great call to action, Mike. Appreciate that. And listeners, please do what Mike is asking you to do. It's a great idea. Let's move into a little bit about your career, Mike. First of all, why did you go into the practice of law?
Well, a couple of reasons. I actually intended to go to business school and did one quarter. It was quarters, not semesters back then, and really found it boring. And I love to argue, and that's what happened around my dinner table. We had a very politically active family, very engaged, and eventually it came to me to seem like the better fit for me. And so I did have a few years between college and law school, but I decided that's where I wanted to be.
And when you first got out of law school, tell us a little bit about your career and how it's changed through the years.
Sure. Well, it's funny. I was a big moot court person in law school. And so I really came out wanting to do appeals. There really wasn't such a thing as an appellate practice at that point, but I was given the opportunity to argue a couple of appeals even in my first year at our firm. But my practice was largely a commercial hourly trial practice for a number of years. I worked with, great lawyers at the firm, Emmett Bondurant, Mickey Mixon, et cetera, and got to try cases with them and learn a work ethic and a way of doing things that I think has served me very well. Over the course of years, I began doing, again, a few years later, more and more appeals. And I started handling appeals in some fairly large cases where I'd been on the trial. And really, the appellate practice as a separate practice came out of that. And it was the Six Flags Time Warner case and the work that I did on those appeals. A large plaintiff's verdict with many of the same issues came up to the 11th Circuit shortly after that case was over. And Mike Bowers was the plaintiff's lawyer with a $20 million-ish verdict. And he hired me to handle the appeal because I had handled many of the same issues in the Six Flags case. And we had a great victory in that case for Mike. And he gave me a lot of credit in the press for sort of steering that victory. And he was extraordinarily gracious and kind to me. And I started receiving more calls for other appeals after that. And over a course of years, I've been able to change it to where my practice is about 75 to 80% appellate. I still try cases. I've tried 3 cases in the last 5 years. And I have a lot of class actions, for class actions. I've got about 4 plaintiffs' class actions where I'm lead counsel at the trial court level. But about 75% of my work is now appeals of other people's cases.
So, Mike, different from what I mainly do or from what Robin mainly does, because we're mainly in the trial courts most of the time. By the time you get a case, a trial lawyer like me has already screwed it up somehow, or at least cast the die, in one direction or the other by whatever we've done below. And I was trying to think. I think I've argued maybe 1 or 2 appeals that I was not involved in the trial court level. But, I get asked to try cases, not to argue them on appeal very often. And how do you go about looking at a case, deciding if there's an appellate issue, because you really do have a lot more things that are decided at the stage that you walk in than the rest of us do.
Well, and that is changing. I mean, over the last 6 years or so, the trial lawyers have started bringing us in earlier. And some of them are bringing us in before they file the complaint, bringing in the appellate lawyers. And I like to participate in the trial. I don't like to just sit there. You know what? Believe it or not, sitting through a trial that somebody else is doing is kind of boring. Even as a lawyer. I know. And so, for example,
I don't think I've ever done that.
Yeah. Well, a lot of times I will be at the trial, and I tried 2-3 week trials a week apart about 3 years ago. And I handled several witnesses in each of the trials because, just give me something to do and take some burden off the other lawyers. But being in early allows you to help shape the record, the theories, the evidence, make sure the objections are preserved, et cetera. Avoiding overreach, which is frequently a battle. But then a lot of times you just get the case when somebody either lost what they thought was a big case or they won big and they want to not lose it on appeal. And so they come to you with the case. Now, sometimes it's crystallized. They lost summary judgment. So the issues on appeal is that summary judgment order. Although when I was first starting out as an appellate lawyer, I made a serious error of judgment in taking on several cases where a plaintiff had lost summary judgment. And I looked at it and I looked at the record and I looked at the briefs and the evidence and I said, that was just a mistake. There's just no way. And I said, I'll take it. And I'll take it on a contingency basis. If I'll get whatever you get, a percentage of what you get if you ultimately win the case. And in those 3 cases, I went forward and got the summary judgments reversed. And what I hadn't done, and many, many years ago, was looked at, well, are we going to win the trial? And sometimes judges grant summary judgment when perhaps they shouldn't, when they're really just putting a weak case out of its misery. And you get the summary judgment reversed, and then you go lose at trial on the exact same issues that the judge saw a scintilla of evidence and maybe shouldn't have granted summary judgment, but he knew where it was going. And so I learned a couple of lessons from winning appeals and not getting paid because the case was then subsequently lost at trial. But frequently
the trial lawyer can screw it up for you on both ends, is what you're really telling us, isn't it?
Well, that's right. That's right. In that circumstance. Now, a lot of times I get hired, mostly these days, I get hired when there's a big verdict. Somebody gets a 20, 30, 50, $70 million, $200 million verdict, and they hire me to try and hang on to it. Hopefully they hire me a little earlier, but usually I will tell you, I've probably gotten 8 or 9 calls just in the last year within an hour of a jury coming back. And I get that call, and then I'm in from that day, working to craft the arguments for J&OV, new trial, et cetera. Matter of fact, I got one in a very large 9-figure case. I got a call a couple of months ago, late last year, and where it was, hey, listen, the jury just came back and the other side's saying this, what do I say? And literally I'm on the cell phone as the verdict has just been read and they're trying to decide whether to release the jury and send them on their way. And I'm providing advice at that point and, trying to run conflicts checks on my cell phone at the same time. But yeah, Lester, you're right. It can get screwed up. But the simple fact is most people don't get a really big verdict without being a good lawyer. And, mistakes happen in the heat of the moment, in the heat of battle, but most people make a good record. And I think people are more careful than they used to be. But I also am a big fan of the trend of getting the appellate lawyer involved earlier and even before the start of trial, if possible.
Well, there's an old joke about how you get $1 million verdict and it's you screw up a $3 million case. But when you're a trial lawyer, you have to react. The best answer you can get in the next 15 seconds, not the best answer you can get, after 15 weeks of study on the issue. And of course, I'm sure you get some, these issues repeat. They're not isolated to a case. So your experience really comes to bear as well. Let me ask you about this. I watched recently watched the arguments in front of the Supreme Court of the United Kingdom when they argued the Brexit. It was really the prorogation of Parliament case that they had there. And so they have, 4 or 5 lawyers, and they each get like 2 hours apiece, to argue their case. And in the Georgia Supreme Court, Georgia Court of Appeals, 11th Circuit, even in the U.S. Supreme Court, you get 15, 20 minutes, maybe 30 minutes if you're lucky. How do you feel about oral argument and about how we do oral argument here in the United States versus how it's done in some other countries where you've got a lot longer time period? And just for our listeners who may watch Law and Order on television where you have a 5-minute closing argument, in Georgia, for closing arguments in a criminal case, you get an hour. And if it's a capital case, regardless of whether the death penalty is sought, you can get 2 hours to argue your case.
2 hours, you actually get 2 hours as of right in civil cases if you ask. It's all in how you ask.
Not a good idea to take 2 hours with the jury, in my opinion.
Well, I mostly agree with you, Robin, but a lot of the cases that we try are like 7 to 12 week antitrust cases, and when you're trying a case where the trial went multiple months, you're going to need that 2 hours, and sometimes you're going to want more. But Lester, the United States Supreme Court used to have day-long arguments. And it basically you argue until the justices get too tired to go on, and the time limits are both good and bad. It really makes you organize and crystallize your issues to that which is really important. I frankly think the time limits give an advantage to people who do it a lot, because you learn how to structure things around the time limits. And it also varies greatly court to court. For example, in the 11th Circuit, I generally come in with the understanding that I'm not going to be given more than 45 seconds to 2 minutes to talk before the rest of the time is taken up with questions. And that's largely true, not as true, in the Georgia Supreme Court. They let you talk a little more and let you make your arguments rather than just answering questions. But we refer internally, when we prepare our lawyers, to the 11th Circuit as a question court. And the preparation is preparing for the questions, and it's not a monologue at all. And so, but managing your time is difficult or close to impossible when someone else is doing the questioning and driving the agenda. And so you just have to learn to transition. You have to work on transitions. You have to be able to take an answer to one question and turn it into the affirmative point that you wanted to make. And we actually practice those techniques in advance of an argument.
Or, Mike, for a 20-minute Georgia Supreme Court argument, how many hours would you say you prepare for a 20-minute argument?
So that's enormously variable. I would say anywhere from 30 hours to 200 or 300 hours. So Nesselhut, I think we did more than a dozen moot courts, and each moot court was 45 minutes to 3 hours long. And that was spread over a month or two. And to be honest, we had a predecessor case that got within a week of argument. Same issue. So we'd spent a good bit of time prepping. And so and I would say prep time has gotten shorter over the last 5 or 6 years because I've had a lot of repetitive issues. So I've argued apportionment, for example, in the appellate courts 5 times this year. And yeah, so you don't need to prep the same case law as much when you're arguing the same issues repetitively.
So you get, with the Nesselhut case you're talking about, you only got one at 7-0 because you'd have 9 justices at that point. Now we've got 9 justices on the Georgia Supreme Court. 3 judge panels are pretty typical in some of the other appellate courts. But, you get a wide variety of judges up there. You got people like Clarence Thomas, who, until the advent of some of the teleconference arguments recently, never really asked a question. It was a news item if Clarence Thomas asked a question. You've got other judges and justices who seem to think they're the only one that gets to ask questions. So you get a wide variety of different people in the audience that you're trying to persuade, and you probably know going in that some are more persuadable than others, and that there are certain ones that you have to win in order to do that. So how do you parse all that out in your strategy?
So it's actually case by case, judge by judge, justice by justice. And this is a lot of the prep that goes into this. And I'll talk about one case as an example of that. But, in the Georgia Court of Appeals, we're getting 3 judge panels. And you know who your 3 judges are, though it changes with recusals, retirements, et cetera. But from the date your case is docketed. In the 11th Circuit, it's 3 judge panels. You don't know who they are until 2 weeks before the argument. But the argument is particularly where you have a panel where it's a variable mix. It's not the same 7 or now 9 justices on the Georgia Supreme Court. One of the things I like to do, judges are people, and they have all the foibles and strengths that ordinary people have. And for example, if I'm arguing an issue in a Georgia Court of Appeals, and I've got a point on which there are multiple cases that I could cite for a particular purpose, look for one going your way, written by one of the judges on your panel. Remind him or her that they wrote this. These are your words and they're right. And because judges don't want to, first, they believe what they said. Second, they don't want to appear inconsistent. And third, they don't want to be inconsistent. And so if you can say, you've previously said this, this is what you said, I think that carries some weight. Now, of course, in the Supreme Court, you've got 9 of them up there, and you can't tailor it as tightly to any one, except sometimes you walk in and Justice X is my problem here today. Based on what she has written, she's going to be a problem on this case, or he's going to have a burr under his saddle on this issue. And so you prepare justice by justice in that respect, even in the Supreme Court. And you have to know, and you frequently do know, who are going to be the frequent questioners, who's going to press you. And our Georgia Supreme Court has, over the last few years, gotten a lot more aggressive in its questioning. And there are some great questioners. There really are. We don't have as much as the U.S. Supreme Court has of people using their questions to fence with or lobby with the other justices. Mostly our questions are, I need your position on this to decide the case, or I don't understand this argument, explain it to me better, or I'm not seeing this in the record, tell me what your basis is for saying that. And the questions in our court, in my mind, are better structured towards getting to the right answer rather than political fencing. And so I'm really happy with a lot of the questioning that we are getting these days.
Well, it's probably fair to say that in the U.S. Supreme Court, that a lot of the questions, the purpose of the question is clearly for the justice to broadcast what their opinion is about a certain issue, as opposed to really being a true question that you want answered. That's my observation. Would you agree with that?
I do agree with that, and also to try and lobby or persuade the other justices. So.
My personal experience, especially in the Georgia Supreme Court, is you cannot tell which way the case is going to come out based on the questions, because just when I feel like they are really hammering the other side, I get up and argue and they hammer me. Just their equal opportunity hammering questions. You can't tell which way it's going to go because they're very Socratic and they dig deep at your weakness on each side.
They do. But sometimes you can tell, I've had a judge go like, I'm just not buying that argument. You better come up with something else because I'm not buying that. Now that's one, but sometimes they're pretty open about what they're thinking and where they're going. And other times they're just questioning you because they want to test the soundness of your legal reasoning and poke and prod, and they're doing that to both sides because maybe they're really not sure where they're going to go yet. So yeah, but
I do remember an argument, and I don't remember the issue, but it was over the way a lawyer had treated another lawyer. And I remember Judge Herb Phipps, when he was on the Court of Appeals bench, in oral argument, say, "Is that the way we really treat other lawyers in Georgia?" And to get that kind of question from a judge or a justice, you know you've done something wrong. That was like a low moment for that lawyer. I don't even remember what the issue was, but never want to have that happen.
Well, I had a case in the Georgia Court of Appeals a couple of years ago where when the lawyer on the other side finished and went to sit down, one of our judges said, "I need you to come back to the podium for a minute." I was reading through the discovery responses and the objections, and we're going to have a chat about professionalism. And and their time was up, but but there was, and I was sort of stunned as sitting on the other side, and I wasn't really sure whether I wanted to grin or whether I was really uncomfortable, and there was just a little, like about a 1 minute. That's not how Georgia lawyers do things, and I don't want to see that in the next record that comes up in one of your cases. Yeah.
So let me ask you about something that our non-lawyer listeners may not know what it is, but it's called stare decisis. Meaning that the court opinions are precedent to be used in other cases. You've talked a little bit about how you use that. Somebody once said that there'll never be a Nobel Prize in law because it's the only discipline that does not reward original thinking, that in order to get something done, you have to have shown that it's been done before by somebody else in the ancient past. Just as a principle, as a general matter, is stare decisis a good thing? The idea that you've got to have a case that shows this issue has been resolved this way or close to this way before you can win the case that's currently before the court?
Well, stare decisis. I mean, in Georgia, we have statutory precedential rules. I mean that the opinions of the Georgia Supreme Court are binding on the Court of Appeals. The opinions of the Court of Appeals are binding on the lower courts. That's enforceable here. Now, but the general legal principle of stare decisis has great utility as long as it is taken as a general principle and not as an absolute rule. So the great thing about stare decisis is it brings into the law an element of predictability. It allows people to govern their conduct by looking at what the law allows and does not allow, and you're not generally going to do something and then find out later that something you had been told forever was perfectly fine is now sanctionable, a tort, whatever. And so having predictability in the law and in society and in the actions of people governed by our laws is a great thing. But the law has to evolve. It's draw the line from Dred Scott to Brown v. Board of Education, and the law changes, and it's not stare decisis that is making that changes. It's hopefully an iterative change, but sometimes it has to be revolutionary rather than simply evolutionary. And I think a lot of times our courts step up to the plate when that's necessary, and a lot of times they don't. So stare decisis has a great function. It is useful. It cannot control, or we never advance as a society.
And that would cue Oliver Wendell Holmes. The life of the law has been logic, has not been logic, but experience, I suppose.
I think that is right.
Mike, let's talk a little bit about some of your more renowned cases. We've mentioned the Nesselhut case. We call it Nesselhut because she was the plaintiff. I call it Nesselhut because I represent plaintiffs, and she was the plaintiff. And but the appellant, the person who, the entity that lost below was Atlanta Oculoplastic Surgery, her doctors, and they lost in the court below, and then in the Supreme Court, they bring the appeal to the Georgia Supreme Court. Case tried by our mutual good friend, Adam Malone, received a $1.265 million verdict, and then you enter for the appeal. Tell our listeners a little bit about what that issue was that you, it was a very big deal, obviously, in our jurisprudence in Georgia. So can you fill our listeners in on that case?
Sure. And so, there was a previous case, Lance Laurie's case, that had the same issue teed up. And it was the issue of the constitutionality of the cap on non-economic damages in medical malpractice cases. And of course, the thinking was of the General Assembly and of the Chamber of Commerce that we're going to put caps on all kinds of damages. And they ran out in the med-mal one first because of a perceived crisis in medical malpractice verdicts. So we challenged this. And in the first case, we were very close to oral argument. It was an extraordinarily sympathetic case, where we had a paraplegic client because of medical negligence. And, the capped amount just seemed paltry and ludicrous. And then right when we were getting ready to go up with that very sympathetic case, Justice Sears, who was reputed to be one of our more liberal justices, announced her retirement, and our Republican governor was going to appoint a replacement. So the defendants settled that case, resolved that case, it went away. And then the next one up was Adam's case, and which they saw that as a great test case because, as they described it, misdescribed it, but it was she was unhappy with her facelift. And of course, it was much more substantial and serious, and her injuries were really horrific. But and so I had been hired to handle the appeal in the first case by Watkins Laurie. And so Adam called me, and I came into the trial court post-trial in Nesselhut and argued the constitutional challenge in the trial court in front of Diane Besson. And trial judge Diane Besson ruled our way on the constitutional challenge, making the other side the appellants. And by the time it went up, David Namias had replaced Justice Sears. And so I think the thinking on the defense side was we have a more conservative bench, we have a less compelling case without the paralysis and with the ability to call it a botched facelift. And so this was their test case. We went at the appeal as we went at it in the trial court on a number of fronts. Violation of the right to jury trial, separation of powers, in that we believe constitutionally only trial judges could reduce verdicts, and for the General Assembly to do a one-size-fits-all across the board reduction of certain verdicts violated the separation of powers. We had a due process, equal protection claim, et cetera. We went in and argued the case. It was, I think the perception going in was that we were behind 4-3, but the way the argument went, I walked out after the argument and was asked by a reporter, how's it going to turn out? And I said, we're going to win 7-0. And then I went home and panicked.
Wished you hadn't said that.
I really wished I hadn't said that. But, and I spent, of course, the next few months until the opinion came out, agonizing over it. And the weekend, they in Georgia Supreme Court announces on Friday afternoon its opinions. And there's a story I'll tell you sometime about why my weekend was horrible waiting for that opinion. But in any event, we won 7-0, and they utilized basically the right to trial by jury. They didn't reach the other issues. In
the Georgia Constitution.
Right. The Georgia Constitution has a slightly differently phrased jury trial right than the federal Constitution. And we picked up on that, focused on that. And essentially the holding was that issues which had been for the jury at the time of the adoption of the first Georgia Constitution could not be taken from the jury by legislation, but would require a constitutional amendment to take such issues from the jury. And the amount of damages for non-economic damages was an issue that was for the jury. at common law before the adoption of our first Constitution. And this actually is one of these little learning experiences. One of the things we heard from the other side was, well, there were not even any medical malpractice cases at the time of the adoption of the first Georgia Constitution. It didn't exist. So it couldn't be that non-economic damages and medical malpractice. And this is one of those sort of gotcha moments where, I said, there's a problem if one just plugs in the word malpractice into Lexis or Westlaw, and you don't see any cases earlier than the adoption of the first Georgia Constitution. The problem is the spelling changed over time. And it was 2 words, malapraxis.
Oh, did not know that.
And it was called the tort of unskillful surgery. And so there were cases, and they were out there, and that's a bad moment when you say, well, this didn't exist at common law, and I'm like, well, let me read to you from Blackstone's commentaries, about malapraxis and the tort of unskillful surgery. So that's all part of those many moot courts that we did to get ready for that argument.
And in Nesselhut, in that opinion, interestingly, who the defense thought might have been their new champion on the Supreme Court, Justice Namias, actually wrote a very lengthy special concurring opinion. Might have been longer than the actual opinion of the court.
Yeah, and one of the issues in the court was, if you're going to declare a statute unconstitutional, is that retroactive to cases that were decided before the decision? And that was really the issue he focused in on, and did, I think, a very scholarly analysis of that issue in his concurrence. So that was a great case and a great moment because of the sort of societal impact, and I think it stopped the plan to adopt caps on a number of torts. And sort of put a constitutional stamp on that effort.
And so if there is ever another effort to try to limit non-economic damages in a personal injury case, now because of that opinion in Nesselhut, it would have to come from a constitutional amendment. Is that correct?
That's right. And so essentially, and it's a little broader than that too. It's essentially any issue that was for the jury can't be taken from the jury by legislation. And so that's sort of the, but it's a common law doctrine and based on the language of our Constitution.
All right. Let me talk to you, and let's have your listeners hear about another great case that you argued on appeal, Martin versus Six Flags over Georgia. And that was both a premises liability case, and it also involved issues of apportionment. And you've argued, I think you said 5 times on apportionment.
This year.
Well, apportionment was also part of that 2005 tort limitations package from the Georgia legislature. Caps on damages was part of the 2005, it's notoriously known as SB 3. You got that overturned. Apportionment's still with us, but it's certainly been litigated and discussed in appellate opinions. But let's talk a little bit about Martin versus Six Flags. In that case, Martin is in the Supreme Court the appellant, meaning he lost in the court below, correct?
Yeah, and I'm the one who argued and lost it in the court below. So yeah, although I have to say it was not. It was a very partial loss in the Court of Appeals, because basically the appeal challenged liability at all, because the premises liability case and the injuries and attack occurred about 200 yards away from the premises. And so the defense had argued that there simply can be no premises liability because it's off premises. And so they were asking for a JNOV, that is, verdict as a matter of law. And so we won that issue in the Court of Appeals. And they said, no, there's a claim. You proved your claim. But there, in that case, there were a number of assailants who beat Mr. Martin fairly severely. And some of them were listed on the verdict form for apportionment, and some of them were not. And so it came into.
Mike, can you explain just what apportionment is for our listeners for a minute? Because I know we all know what it is because we've all been practicing law for 30 years, but some folks may not realize that. I didn't mean to interrupt you. I just want to make sure they fully understand that.
The doctrine of apportionment, which, as Robin said, was part of the tort reform package of 2005, is the idea that if multiple people are negligent, in the simplest context, multiple people are negligent and cause my injury, I can sue any one of them that I want to, and that's always been true. What used to be the law is I can sue whoever I want to. I can recover all my damages from that person, and they can then go sue the other negligent people and get reimbursed. And the idea was, look, if somebody has to take the risk that some of the negligent people don't have any money, don't have any insurance, et cetera, it should be the other negligent person rather than the innocent person who was harmed. This was changed in 2005, and the idea became that the defendant or plaintiff, but the parties could insist that the jury, when I sue defendant, Six Flags in that case, that the Six Flags could say, well, we want you to list all these other people who we think were also negligent or committed intentional torts, put their name on the verdict form, and have the jury put a percentage next to each name, and then the damages are split according to those percentages, which have to add up to 100%. And each person, the named defendant that I sued only has to pay the percentage written next to their name. So if the five guys who beat Mr. Martin up got 95% apportioned to them, Six Flags only has to pay 5%. And in that way, the risk of being unable to find, unable to serve, or that the other people simply have no money or no insurance is put entirely on the injured plaintiff rather than on the other negligent parties. And so it becomes an issue of who should be on that form, what level and quantum of evidence is necessary, and procedurally, what do you have to do to get them on the form? And so those are the issues that we talk and fight about a lot. And one of the issues in that case, for example, if 5 people are beating him up and another person who's friends with those 5 is standing there watching or clapping or cheering, or it depends on who you believe, should that person's name go on there? Didn't touch the victim, didn't hit him, kick him, anything else, but was standing there applauding, cheering, whatever, does that name go on the verdict form? And so that was the issues that we dealt with in that case. But the Court of Appeals said, number one, you're right, you can sue for off-premises liability, but because you left some names of people who didn't actually touch him, but were there and arguably, quote, participating off the verdict form, you have to redo the whole trial, go back and do it over. But you are right that you can win even though it was off premises. And so we would have that going for us if we went back. But we didn't want to go back. We had a good verdict. We didn't think there was any reason to go back and redo it. And so we petitioned the Supreme Court for cert, which was granted. And the Supreme Court affirmed the liability issue with slightly different reasoning for the off-premises assault. And then on the apportionment, it said, we agree that one of these names should have been included. But the remedy for that is not to do the trial over, because nothing about that affects the amount of damages found by the jury. And nothing about that affects the fact that Six Flags was found liable and responsible by the jury. And there's nothing wrong with those parts of the verdict. So they sent it back merely to add in that one name and redo the percentages with that name added. And so that, of course, was a victory for us because we got to hold on to the liability against Six Flags without having to redo the trial. We got to hold on to our damages number, and that was that. And the trial didn't even need to be redone because the parties knew how that was going to come out, and so we didn't have to redo the trial at all.
That was a $35 million verdict at the trial, and in that trial, Judge Tanksley, who's the trial court judge, great judge, great friend of mine, allowed four of the gang members who beat up Mr. Martin on the verdict form, and the jury apportioned, I believe, 2% to each defendant. Right. And then you've told us what happened with that you had to do just a trial on apportionment, not on the verdict again. Then in another case, I'm going to talk that you have handled another very large verdict, the Beasley Metatronics International v. Beasley case. Monotronics International v. Beasley case. That was also an intentional assault, a sexual assault on Mrs. Beasley, and a large verdict, I think it was $9 million verdict. Right. And the jury apportioned 4% fault to Mrs. Beasley, 92%, I believe, or tell me if I'm getting this wrong, though. I think 4% to Mrs. Beasley for contributory negligence. And the rest to Monotronics and none to the criminal defendant. Is that right?
That is correct.
So, while we're talking about apportionment, I can remember going back to 2005 when it became our law, a lot of the soothsayers said, "Oh, these kind of sexual assault cases or intentional tort cases are gone because the jury's going to apportion 100% to that criminal defendant." And yet it seems like we're finding, no, the jury is not apportioning much to the criminal defendant. They're making the landowner or the employer or whoever really is the negligent actor bear most of the fault. What do you think about that?
Well, two issues. One is sort of the Beasley had a very particular issue in it, and I'll get to that in a moment. But I mean, the way I explain this to people, let's say that I'm a celebrity and I hire a security company to protect me because I have a stalker. Okay. And everybody knows there's this crazy person out there stalking me. And I go and I hire bodyguards and a security service protect me from this stalker. And on a particular night, the security guards all go off and get drunk and I get attacked by the stalker that they were hired to protect me from. Whose fault is that? We all knew the stalker was there. We all knew there's a criminal trying to do something. They were hired to prevent that very thing. It's really no different than, I hire you to prevent, a flood in my house or to prevent whatever, something you're hired to prevent. It's your fault because that was your job. And a landowner has the non-delegable duty to have safe premises for the people on their premises. And so, I think the jury can say, look, in certain circumstances where the landowner knows, there have been multiple robberies here and you don't put in security guards or security lights, it's really the landowner's fault because they knew it was going to happen. It's almost like, failure to put up a fence around a safari camp in Africa. We know there are lions out there, and so I think it's perfectly natural for the jury to say in those circumstances when you know or should have known, and they always say they didn't know, but there's usually a lot of evidence they did, that it's reasonable for the jury to say, no, that was your job, and we know they're criminals. And sometimes it's your job to protect someone from the criminals. And that's the real reason this happened because the criminals are always out there. In the Beasley case, though, it was a little bit different. In the Beasley case, the jury was not allowed to apportion to the person who pled guilty of the sexual assault because the procedural prerequisites for putting the name on the form were not complied with. And that was really, there were two big issues in that appeal. And the first was the apportionment issue and the idea that you have to give notice of your intent to apportion 120 days before the trial commences. And they gave a notice after the close of discovery before a trial had ever been scheduled. Subsequently, the trial was scheduled to begin less than 120 days after the notice had been given. But there was no trial date when they sent in the notice. And they asked the trial judge, hey, we want you to shorten that 120 days, because I think they were at like 118 or 119. And, can you shorten the 118 days and deem our notice sufficient and put this person on the, and trial judge said no. And that was the first big issue on appeal, was the trial judge right to say no to that. And what the Court of Appeals said on that is, look, what you needed to do is ask for a continuance. The trial judge can't change the statutory deadline. That's a statute. The trial judge can give you a 2-day continuance, and you didn't ask for that. So, not the trial judge's fault. The second thing was there was a contract with the security company there that had a limitation of damages, and in no event, shall we be liable for more than $250. So if we're negligent, you agree that your damages are limited to $250. And frankly, I thought in that case that was the much harder issue. And that issue led me to violate one of the fundamental tenets of appellate practice, which is pick your one or two best arguments and spend your time pounding those home. And I looked at this, and I looked at our panel. And our 3-judge panel had one judge that I knew absolutely I would not get their vote. And under the rules then in effect, that meant we went in bank automatically. And you could figure out then it would roll to 9, and you could figure out who they were. And so actually to 7, sorry, at that time. And so we looked at who they were, and I said, I've got this I think is my best argument. I don't think this judge will buy it. Here's my second best argument. I don't think this judge will buy it. So we ended up making 5 completely separate arguments for why that contractual provision was not enforceable. We won the case 6-1, and all 5 of our proffered reasons were adopted by like one judge, and then one of them had 2 judges. So, yeah, we that's a sort of look at who your judges are, think who you're arguing to. I decided at the beginning of that appeal that we were arguing to 7 people, and that this was not going to be won by us in front of 3. And so we had to brief it differently.
And may explain why there were 4 special concurrences, because
exactly
they agreed
right
with the outcome, but we like this argument better.
It's exactly what happened. Yeah. So that's one where I actually feel we did a great job of structuring and planning our arguments, and using our knowledge of the court rules and the fact that it was going to go to multiple judges, and then being flexible on the normal judicial or appellate practice rule that you only do 1 or 2 arguments.
Yeah, I reread it before today. It's a great opinion, but I noticed on the limitation of liability clause, the main opinion held it wasn't conspicuous enough, I guess, in the body of the contract. But one special concurrence said, well, I don't think it even applies to personal injury. It says property damage. So I thought you were probably making all these different arguments, and some judges latched onto that, other judges latched onto the other one, and it came out the right way, with one dissent, which given that panel, I think we, as plaintiffs' attorneys, all knew who that was going to be.
As T.S. Eliot said, the greatest of treasons is to do the right thing, but for the wrong reasons. In appellate decisions, it doesn't really matter, does it?
Well, it does, Lester, only because we have more cases coming. And so, it's you need the reasoning to be sound and be useful in subsequent opinions. I've used a lot of the Dillard opinion in Italy, and I cite that, for in a lot of cases. But that was just a very complicated case, and those damages limitations are tough.
Well, Robin, are you going to hit him with your favorite, our ending question here?
Mike, I asked you to think a little bit about it. What does justice mean to you, or how would you define justice?
Well, you really picked the wrong person to ask this. And Lester's one of the few people who knows this. I actually published a paper on the concept of justice in 8th or 19th century English and Scottish philosophy. And Lester's one of only about 500. We get these little reports, author reports. Lester's one of only about 500 people who's ever read that paper.
That's true.
I've known you for a long time. I'm not familiar with that paper, Mike.
Well, you can buy it online, but basically, even though I wrote the paper about the sort of the Hobbesian time of justice philosophy, I'm more Aristotelian in my approach, and Aristotle referred to justice as the virtue which was the sum of all others. And I do believe that. Now, and it's really important, I think, today in the days of Black Lives Matters and dealing with systemic racism, to realize that the traditional Greek concept of justice had sort of two parts. There's distributive justice, and that means systemic societal fairness, rights, benefits distributed fairly, that is just. And then there's what's known as corrective justice, and that's what we do in the courts. And corrective justice is where the rights and benefits are imbalanced because of the conduct of a person, whether it's a criminal act, a tortious act, a breach of a contract. Something has been done that was unfair, unjust, and needs to be corrected. And so that's the concept of corrective justice, and that is what we do. But at the end of the day, really, in my mind, most concepts of justice are incredibly personal and mostly subjective. What do you think is fair? What do you think is fair? Now, we see this a lot in litigation, and here's an example that you get a lot in appellate practice because it's a very rule-bound practice. Let's take a party who's technically violated the rules. He filed his brief a week late, okay? And he will argue and truly believe that justice requires ignoring the technicality and focusing on the merits. That is justice. Ignore the violation of the rules and focus on the justice, the merits of the underlying case. While the party on the other side might truly believe, and I've made this argument, that justice means everybody plays by the same rules. Justice means a level playing field, and if you have to enforce the rules even-handedly, enforce them against everyone or not at all. And in some people's minds, that is just. And of course, we all are subject to the simple fact that it all depends on where we're sitting. What I try and do is, I started off with, I want to make my parents proud. I want my parents and my grandparents, if they were told what I did, to say, well, I raised him right. And that's sort of my concept of it. And then later, I wanted my kids to be proud, to be able to look at what I did in a case, look at what I did in society, look at what I did with respect to these protests, and for my children to be proud of what I did, and hold me up as an example. And that is justice. But in the very end, I think that justice is like obscenity or pass interference. I know it when I see it. It is a very personal concept, but it has to be driven by personal conceptions of fairness, because that's if what you're doing, if you feel like you're winning but it's not fair. I have had one appeal many years ago where I thought one of the 11th Circuit judges was so unfair to my opponent that I walked out knowing I was going to win and feeling like I wanted to throw up. And after that case was over, I called that judge and talked to them about what I thought of the treatment of my opponent. I did wait till after the case was over, though. I will admit that. But if it doesn't feel fair, if it doesn't feel right, if it gives you a queasy feeling in the pit of your stomach, that's probably not justice.
All right. Thank you, Mike.
We appreciate it very much.
Thanks for being with us today. It was great to have you on the show, and hope you'll come back and visit with us again.
Well, I enjoyed it. Glad to do it anytime.
Lester and I want to bring our listeners something that struck us in the news this week that is law related. And of course, we have to acknowledge what's going on in our criminal justice system with the Black Lives Matter protesters over the death of George Floyd, what I would call the murder of George Floyd, although no one has been convicted yet. But and the shooting, let's not forget the shooting of Ahmaud Arbery in Glenn County, which we've talked about in a previous episode of this podcast. But the shooting and killing of Ahmaud Arbery, and if you'll recall, that was done by two men and potentially a third conspirator, two men who were not policemen, not part of the Glenn County Sheriff's Department, but they claimed they were making a citizen's arrest of Mr. Arbery. And I believe that law needs to be changed and needs to be repealed. I was happy to see that on Monday, the day of the preliminary hearing in that case in Glenn County, that a bipartisan group of state representatives have filed a bill that will eliminate Georgia's citizen's arrest law. And one of the representatives, Carl Gilliard from Garden City, said that their bill's focus was to prevent civilians from taking the law into their own hands, and that our citizen's arrest law was created in 1863, and this law is clearly outdated as it was formed in the fashion of the Wild West. When individuals lose their lives at the hands of civilians that become judge and jury, we must use the power of the pen to move Georgia forward. So I'm urging our Georgia legislature, when it reconvenes, to end and repeal the Georgia citizens arrest law.
Okay. All right. I'm going to go into the Wayback Machine for a minute, because several years ago, you may have heard of a lawyer in Washington, D.C., who took his pants to the dry cleaners, and they lost his pants. And this resulted in a $67 million suit against the dry cleaner for losing his pants. We hear about these things all the time in the news media. They tend to get people outraged. They tend to undermine confidence in the judicial system, when in fact, as Robin and I know, and others who are familiar with the judicial system, you can ask for whatever you want to. But if you pursue it, and you pursue it by improper means, there's usually not a very good end to it. This lawyer did not get a very good end, because the D.C. Court of Appeals, which is the equivalent of our Supreme Court, has suspended him for 90 days based on the sort of outrageous and unsupported arguments that he made. He initially demanded $15,000 for emotional distress for losing his pants, then $15,000 in punitive damage. This later went up to $67 million, which included $90,000 to rent a car needed to drive to another dry cleaner, and $3 million for emotional distress. And he requested ongoing services from the dry cleaner from a dry cleaner after that. So I think there are a couple of lessons in this. One, when you read about somebody asking for a huge amount of money, let the process work out. See what the evidence is, because that doesn't happen in a lot of cases where it's not merited. The second thing is that in this time when we're talking about misconduct in a lot of professions, and particularly the law enforcement community is under the microscope with regard to members of that profession, a small minority that are engaging in misconduct, it's nice to know that in the legal profession, that those that engage in misconduct, like this lawyer did, actually do have to step up and pay the piper at the end of the day.
Absolutely, Lester. Great example of our civil justice system doing the right thing and working it out. That's all I have. Lester, anything else you want to?
Nothing for me, but I hope that folks will tune in next time, and we hope to see you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robinfrazierclark and Lestertate, until our next episode, we'll see you in court.